A very good morning to everyone present here. To welcome is to show honor. To welcome is to establish integrity. I am extremely happy to welcome Sri Tapas Kumar Sahoo, learned advocate from Honorable High Court at Odisha, to come to the dais. Sir, kindly come to the dais to share your knowledge with us.
Jai Guru. It's my immense pleasure now to invite on the dais Advocate Tapas Sahoo from the state of Odisha, practicing in the High Court of Odisha Cuttack, specialized in civil and criminal matters, criminal laws, will now deliver his speech on intellectual property laws. Please welcome Advocate Tapas Sahoo. Momento. That's it. Please.
Small token of gift from Vidhi.
A small token of gift from Vidhi Vidat.
Good morning. Very warm welcome to all of you. Today, I am very much delighted that our advocate friends and all my brothers and sisters, they have participated in this seminar, and from all over from every corner of India, everyone has come here and participated in this seminar. I am very much delighted. Actually, intellectual property rights, normally we think this is related to only intellectuals. In very short span of time, I will try to cover up all the aspects of intellectual property. After that, we may have a question-answer session. So, the World Intellectual Property Organization describes intellectual property as the creation of the mind, inventions, literary and artistic works, and symbols, names, images, and designs used in commerce. It is mostly intangible in nature. Intellectual property is protected by law. For example, patents, copyrights, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. The development of any society directly depends on IPR and its IPR policy framework. Lack of IPR awareness results in the death of inventions, high risk of infringement, economic loss, and decline of an intellectual era in the country. The origins of India's IPR system date back to British colonial rule, when as a colony, the state enacted various rules and enforcement mechanisms pertaining to IP rights. Post-independence, India retained elements of these structures while updating some guiding regulations and other bureaucratic structures. As India moved towards liberalization, privatization, and globalization in the 1990s and later, Indian policymakers made further adjustments to keep up with the growing needs of domestic and international stakeholders. Indian IPR laws fully conform to the agreement on trade-related aspects of intellectual property rights that is known as TRIPS agreement under World Trade Organization. National Intellectual Property Rights Policy, adopted in May 2016, is a giant leap by the Government of India to spur creativity and stimulate innovation. It lays the roadmap for the future of IPRs in India. The policy seeks to reinforce the IPR framework in the country that will create public awareness about economic, social, and cultural benefits of IPRs among all sections of the society, stimulate IPR generation and commercialization, modernize and strengthen service-oriented IPR administration, as also the enforcement and adjudicatory mechanisms for combating IPR infringements. There are various forms of intellectual property like patents, trademarks, copyright, industrial designs, geographical indications, semiconductor integrated circuits layout design, trade secrets, protection of plant varieties and farmers' rights, biodiversity. Let us discuss it one by one. Patents, which is covered under Patents Act 1970. Patent is an exclusive right granted for an invention which is a product or process that provides a new way of doing something or offers a new technical solution to a problem. It provides protection for the invention to the owner of the patent. The protection is granted for a limited period of 20 years. In order to be patentable, the invention must be novel, it must involve an inventive step, or it must be non-obvious, and it must be industrially applicable. Patent protection means that the invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. A patent owner has the right to decide who may or may not use the patented invention for the period in which the invention is protected and the right to initiate legal proceedings against infringement. The patent owner may give permission to or license other parties to use the invention on mutually agreed terms. The owner may also sell the right of invention to someone else, who will then become the new owner of the patent. Once a patent expires, the protection ends and an invention enters the public domain. That the owner no longer holds exclusive rights to the invention, which becomes available for commercial exploitation by others. Patents are territorial rights, which means that an invention is only protected in the countries or regions where patent protection has been obtained. In other words, if you have not been granted a patent with effect in a given country, your invention will not be protected in that country, enabling anybody else to make, use, import, or sell your invention in that country. I would like to mention one famous case which belongs to this Patent Act. You might have known this case. The Novartis versus Union of India in 2013, this case was a landmark judgment in Indian patent law that has had a profound impact on the interpretation and application of patentability criteria in the country. This legal battle centers around Novartis' patent application for the cancer drug Gleevec, composing the chemical substance imatinib mesylate, claiming that it was more effective in fighting leukemia and other cancers and has far-reaching implications for the pharmaceutical industry. The Supreme Court case hinged on the interpretation of Section 3D. The provision aims to prevent the practice of evergreening, where pharmaceutical companies make minor modifications to extend patent protection and maintain monopolies. The Supreme Court decided that the substance that Novartis sought to patent was indeed a modification of a known drug, the raw form of imatinib, which was publicly disclosed in the 1993 patent application and in scientific articles. That Novartis did not present evidence of a difference in therapeutic efficacy between the final form of Glivec and the raw form of imatinib, and that therefore the patent application was properly rejected by the patent office and lower courts. The Novartis judgment has significant implications for the prevention of evergreening and the promotion of access to affordable medicines. It strikes a balance between protecting intellectual property rights and safeguarding public health interests. Now coming to the second part, trademarks. Trademarks, which is covered under Trademarks Act 1999. A trademark is a distinctive sign that identifies certain goods or services as those produced or provided by a specific person or enterprise. It may be one or a combination of words, letters, and numerals. They may consist of drawings, symbols, three-dimensional signs such as shape, packaging of goods, audible signs used as distinguishing features. It provides protection to the owner of the mark by ensuring the exclusive right to use it to identify goods or services or to authorize another to use it in return for payment. It helps consumers identify and purchase a product or service because of its nature and quality indicated by its unique trademark. Registration of trademark is prima facie proof of its ownership, giving statutory right to the proprietor. Trademark rights may be held in perpetuity. The initial term of registration is for 10 years. Thereafter, it may be renewed from time to time. The landmark judgment on this subject, Yahoo Inc. versus Akash Arora and another in 1999. The case relates to unauthorized registration and use of internet domain names that are similar and identical to registered trademarks and service marks, also known as cyber squatting. In this case, the defendant was using a domain name Yahoo India, which was extremely identical to that of the plaintiff's Yahoo. It was held that defendant's Yahoo India has the potential to confuse and deceive internet users into believing that both are the same and belong to the same Yahoo. The court explained that a disclaimer in this regard by the defendant to make people aware is not sufficient, and it is immaterial if the term Yahoo has a dictionary meaning, as over the years Yahoo has already acquired distinctiveness and uniqueness as required under the trademark law. The High Court has also held that domain names on the internet are used by business groups for the same purpose as any trademark or service mark. There is also another case, Pfizer Productions Inc. versus Mr. Altamas Khan, 2006. The Delhi High Court held that cyber squatting is not permitted under the Trademarks Act 99. The court found that the defendant registered the domain name Viagra.in with the sole objective to sell it to interested parties on premium, which is not permissible. Now coming to the third part, Copyrights Act, which is covered under Copyrights Act 1957. Copyright is a legal right given to creators of literary, dramatic, musical and artistic works and producers of films and sound recordings. The kind of works covered by copyright include novels, poems, plays, reference works, newspapers, and computer programs, databases, films, musical compositions, and choreography, paintings, drawings, photographs, sculptures, architecture, and advertisements, maps, technical drawings. Copyright subsists in a work by virtue of creation, hence it is not mandatory to register. However, certificate of registration of copyright serve as prima facie evidence in court of law. Creators often sell the rights of their works to individuals or companies best able to market the works in return for payment. The copyright term varies according to the nature of the work. 60 years from the death of the author in case of literary, dramatic and musical artistic work, and 60 years after publication of a photograph, film or sound recording. I am placing this case before you because I am my close association with SATSANG. In copyright law, you will find thousands of cases, but I have chosen this case because of my close association with SATSANG. There is a case in 1972, SATSANG versus Chandra Mukhopadhyay and others. What happened in this case? A religious preacher, Sri ANUKUL Chandra Chakravarti, better known to his followers as Sri ANUKUL Thakur, wrote a Satyanusaran in his own hand as early as 1910, recording some of his religious teachings and precepts which were published in book form the first time in 1919. In 1925, he founded a society of religious brotherhood of his followers called SATSANG, which had a publishing unit known as SATSANG Publishing House at Deoghar. The object of the society was to propagate the ideals of the Thakur. In due course, the society brought out 3 publications of his writings and discourses entitled Anushruti in 1949 and Alochana Prasange, 2 volumes in 1969. An exclusive license to publish his works was given by Sri Thakur to his eldest son, Amrendranath Chakravarti, in 1957. Around 1970, 3 publications containing the writings and teachings of Thakur were brought out by 2 of his disciples, Kiran Chandra Mukhopadhyay and Kumud Bandhu Bal, which contained exclusive reproduction of preachers' writings and sermons taken from the works published by the SATSANG. And noticing the same, the society filed a suit and applied for an interlocutory injunction against the defendants. The Honorable Kolkata High Court ruled that the writings and sermons of a religious preacher compiled on his behalf would come within the meaning of literary works and pass interlocutory injunction. Now coming to the 4th part, industrial design, which is covered under Designs Act 2000. Industrial designs refer to creative activity which result in the ornamental or formal appearance of a product, and design right refers to a novel or original design that is accorded to the proprietor of a validly registered design. Industrial designs are an element of intellectual property under the TRIPS agreement. Minimum standards of protection of industrial designs have been provided for. As a developing country, India has already amended its national legislation to provide for these minimal standards. The essential purpose of design law is to promote and protect the design element of industrial production. It is also intended to promote innovative activity in the field of industries. The existing legislation on industrial designs in India is contained in the new Designs Act 2000, and this will serve its purpose well in the rapid changes in technology and international developments. India has also achieved a mature status in the field of industrial designs, and in view of globalization of the economy, the present legislation is aligned with the changed technical and commercial scenario and made to conform to international trends in design administration. This replacement act, because previously it was Indian Patents and Design Act 1911, and after that it was substituted by this Designs Act 2000, is also aimed to enact a more detailed classification of design to conform to the international system and to take care of the proliferation of design-related activities in various fields. An industrial design is registered for a period of 10 years and is extendable for another 5 years. There is a famous case which has very great impact on this Design Act. Whirlpool of India Limited versus Videocon Industries Limited in 2014. This case was a watershed moment in Indian design law, Addressing the issues of design infringement and passing off, the dispute revolved around the Pebble model. Pebble model is a semi-automatic washing machine introduced by Videocon Industries Limited that showed a remarkable resemblance to Whirlpool's registered design of its S model washing machine. Whirlpool sued Videocon, stating that Pebble's design was a forgery of its S washing machine, infringing on its registered designs and confusing customers. After reviewing the evidence, the Bombay High Court found that Videocon's Pebble washing machine did indeed infringe on Whirlpool's registered designs. The court found that the two washing machines had a strikingly similar general look, particularly in terms of the design and structure of the wash and spin areas. The court also determined that Videocon's objective was to capitalize on Whirlpool's goodwill and reputation by mimicking the design of its popular washing machine. Videocon's acts were considered to be passing off since consumers were likely to be deceived into thinking the Pebble washing machine was a Whirlpool product. The Bombay High Court issued a permanent injunction prohibiting Videocon from manufacturing, selling, or offering for the sale the Pebble washing machine in its decision. Whirlpool was granted damages for infringement of its copyrighted designs and passing off. The Whirlpool versus Videocon decision established a precedent in design law, highlighted the necessity of preserving original designs and avoiding unfair competition through design limitation. It also emphasized corporations exercising due diligence while designing products in order to avoid future infringement lawsuits. Now coming to the fifth part, geographical indications, which is covered under Geographical Indications of Goods Registration and Protection Act 1999. GI tags are signs used on goods that have a specific geographical origin and possess qualities or a reputation that are due to that place of origin. Agricultural products typically have qualities that derive from their place of production and are influenced by specific local factors such as climate and soil. They may also highlight specific qualities of a product which are due to human factors that can be found in the place of origin of the products, such as manufacturing skills and traditions. A geographical indication points to a specific place or origin of production that determines the characteristic qualities of the product that originates therein. It is important that the product derives its qualities and reputation from that place. Place of origin may be a village, a town, or a region or a country. It is an exclusive right given to a particular community, hence the benefits of its registration are shared by all the members of the community. The term of geographical indication protection is 10 years. In 2017, few years back, there was a fight we all know in social media and off it about the famous Rasagulla. I belong to Odisha and you people belong to West Bengal. We fought over this Rasagulla and this is coming under this GI tag. In 2017, West Bengal received GI tag for its variety of Rasagulla, which led many people believing that the sweet delicacy originated in West Bengal. This led to a fight between Odisha and West Bengal, both on social media and off it too. The tug of war between West Bengal and Odisha ended in a draw, with Odisha also being granted the GI tag for Odisha Rasagulla, that is less than 2 years after the West Bengal owned the GI tag for its Rasagulla. But the whole world knows that Rasagulla belongs to Bengal. West Bengal claimed that the idea of this delicacy was conceived by Nabin Chandra Das in 1968 at his Bagbazar residence in Kolkata. Odisha claimed that their Rasagolla dates back to the 12th century. During the festival of Niladri Bijay, Lord Jagannath offers Rasagolla to his disgruntled wife, goddess Lakshmi, on his return from a 9-day-long Rath Yatra. And there is mention of the word Rasagolla in the 15th century Odia Dandi Ramayana written by the medieval poet Balram Das. There are many other Odia and Sanskrit texts to prove that chena, as you call chana, or cottage cheese, was known to Indians much before Portuguese arrived in India. While there are multiple claims that the process of chana making was introduced first in Bengal by the Dutch colonists of Bandel in late 18th century. In its submission before the GI register, the Odisha Small Industries Corporation Limited, which has been awarded the GI tag, said Odisha Rasagolla is very soft to feel, juicy and non-chewy in consistency and can be swallowed without teeth pressure. The Rasagolla prepared in other places is circular in shape, milk white in color and basically spongy and chewy in consistency. Now coming to the sixth part, layout design for integrated circuits, which is covered under Semiconductor Integrated Circuits Layout Designs Act 2000. Semiconductor integrated circuit means a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic circuitry function. The Semiconductor Integrated Circuit Layout Design Act 2000 protects original inherently distinctive layout designs that have not been previously commercially exploited, and registration is a necessary prerequisite for protection. The main focus of SICLD Act is to provide for routes and mechanisms for protection of IPR in chip layout designs created and matters related to it. The SICLD Act empowers the registered proprietor of the layout design an inherent right to use the layout design, commercially exploit it and obtain relief in respect of any infringement. The initial term of registration is for 10 years. Thereafter, it may be renewed from time to time. Ministry of Electronics and Information Technology is the administrative ministry looking after its registration and other matters. The day is not so far when India will become a global power in the manufacture of products for the semiconductor sector. Prime Minister Narendra Modi said on Wednesday, as he laid the foundation stone for 3 major semiconductor projects, 2 in Gujarat, 1 in Assam, valued at approximately 1.25 lakh crore. India is collaborating with US, Europe, UK, Japan and Singapore to become a semiconductor manufacturing hub. Now coming to trade secrets. It may be confidential business information that provides an enterprise a competitive edge may be considered a trade secret. Usually, these are manufacturing or industrial secrets and commercial secrets. These include sale methods, distribution methods, consumer profiles, advertising strategies, lists of suppliers and clients, and manufacturing processes. For example, the composition of Coca-Cola is a trade secret. Contrary to patents, trade secrets are protected without registration. A trade secret can be protected for an unlimited period of time, but a substantial element of secrecy must exist, so that except by the use of improper means, there would be difficulty in acquiring the information. Considering the vast availability of traditional knowledge in the country, the protection under this will be very crucial in reaping benefits from such type of knowledge. The trade secret and traditional knowledge are also interlinked with the geographical indications. Now, protection of plants, varieties and farmers' rights. The concepts of plant breeders' rights arises from the need to provide incentives to plant breeders engaged in the creative work of research which sustains agricultural progress through returns on the investments made in research and to persuade the researcher to share the benefits of his creativity with society, with a view to provide for the establishment of an authority to give an effective system of protection of the rights of plant breeders and farmers, and to encourage the development of any new varieties of plants and to give effect to the provisions of TRIPS agreement, the government enacted the Protection of Plant Varieties and Farmers' Right Act 2001. This act seeks to stimulate investment for research and development both in public and private sectors for the development of new plant varieties by ensuring appropriate returns on such investments. It also seeks to facilitate the growth of the seed industry in the country through domestic and foreign investment to ensure the availability of high quality seeds and planting material to Indian farmers. It also recognizes the role of farmers as cultivators and conservers and the contribution of traditional, rural and tribal communities to the country's agro-biodiversity by rewarding them for their contribution through benefit sharing and protecting the traditional rights of the farmers. Now coming to the last part of intellectual property rights, that is biodiversity, which is covered under Biological Diversity Act 2002. In simple terms, biodiversity or diversity among various life forms within the biosphere refers to biodiversity. Biodiversity is the foundation of life on Earth. It is crucial for the functioning of ecosystems which provides us with products, services without which we cannot live. By changing biodiversity, we strongly affect human well-being and the well-being of every other living creature. India is one of the 12 mega biodiversity countries of the world. With only 2.5% of the land area, India already accounts for 7 to 8% of recorded species of the world. Over 46,000 species of plants and 81,000 species of animals have been recorded in the country so far by the Botanical Survey of India and the Zoological Survey of India. In the Convention of Biological Diversity 1992, Rio de Janeiro, the member countries were pressurized to change their IPR laws to conform with the TRIPS agreement. India also followed the suit by placing in place legal frameworks for the management of biodiversity and intellectual property laws. Following India's ratification of the Convention on Biological Diversity at international level, the Biological Diversity Act 2002 was adopted. The Biological Diversity Act aims at conservation of biological resources and associated knowledge as well as facilitating access to them in a sustainable manner and equitable benefit sharing out of the utilization bioresources to the country and its people. 1995, two Indian nationalists, this is a case of biopiracy. What happened? In 1995, two Indian nationalists at the University of Mississippi Medical Center were granted US patent on the use of turmeric in wound healing. The Indian Council of Scientific and Industrial Research, that is CSIR, opposed this after its grant on the ground that use of turmeric for healing wounds and rashes has been in the public domain of traditional knowledge for thousands of years. Basing on the documentary evidence of Sanskrit text and a paper published in the Journal of Indian Medical Association 1953, the US Patent Office upheld the CSIR objection and revoked the patent. Now, I would like to conclude with these notes. Today, India is on its way to adopting a balanced approach towards creating a stimulus for the betterment of the IPR industry as a whole. Recent developments in India, be it in the new IPR policy or providing an effective toolkit in the form of checklist that will act as a reckoner for the police to deal with IP crimes or encouragement to innovators in terms of speedy patent examination in case they file first in India, all are part of much needed attempt to improve the overall security of IPR and encouragement to create more IP in the country, because the material-based society is changing into knowledge-based society. There are debates involving around whether artificial intelligence developers or users should hold intellectual property rights for artificial intelligence generated content. Existing laws allow only work created by human skills for copyright. Patent law only allows humans to be inventors. The law is silent and not clear about AI assisted or AI created work. India is having all the resources in terms of available raw material, cheap labor, innovative and creative dedicated manpower. No doubt, India will definitely harness its proportionate share in global trade by exploring in intellectual property rights and mark its footprint on international map as Creative India, Innovative India, Rachanatmak Bharat, Abhinav Bharat. Thank you. Thank you all. Mobile that আপনার মোবাইলটা আছে খালি দেন একটু দেন এক মিনিট খালি I don't know how far you have understood my speech. In very simple language, lastly I want to conclude. This mobile, every day we are using this mobile. The logo or the brand name is covered under trademark. The outer design shape is covered under Design Act. The Android system or operating system, that is covered under Copyright. And the technology, that is covered under Patents Act. Thank you.
I hope that all of you will have a productive day of interesting and stimulating discussion. If you have any question to ask, please ask our eminent speaker. Anyone from the audience, students? Anyone?
Everyone has understood whatever I said. That is my credibility.
Thank you, sir. Thank you for such a thorough. Oh, okay. Sir, one person is there. Sir, kindly say your name.
So first of all, Jai Guru and good morning to everyone. So I'm from here, right on your left. Sir?
Yes, please.
Sir, I have a question. As a layman, like, can I patent a jewelry design? And if I can, if somebody steals or not steal, uses the design and
Jewelry design is coming under Design Act.
Design Act. Yes,
Design.
sir. And if somebody
you can register that design, any kind of design that is having commercial value.
Okay. And if somebody uses it and earns commercial benefit from it, and so which authority should I go to claim my rights?
The design office is in Kolkata.
Okay.
You have the design office in Kolkata.
Okay. Okay. Thank you, sir.
Thank
It
you.
was great to hear from you, sir.
Okay.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, everyone. Thank you.